Hi, this is Frank Stallone, and welcome to All Things P.I. with your host, Scott Ross.
Hi, good morning, and welcome to All Things P.I. It is August 23rd. I have in studio this morning, I have an attorney, Pat Harris. I've actually sort of misrepresented what we were going to talk about with Pat. Pat was Mark Garagos' partner, was instrumental with Scott Peterson in many other cases. And that was what we were initially going to talk about. This morning, though, I wanted to move over to the priests and some other issues that we'll get into. The reason being is because both Pat and I worked on a case by the gentleman up in Santa Clara County, which is also in the news, on the bail issues, and we'll talk about that. But Will Lynch, our mutual client, Pat defended successfully, was a victim, if I remember correctly, help me, it was 1966 he was a victim of assault, he and his brother?
It was a little later than that. It was, I think, 68 or 69.
And Will fell into that category of people that were allowed to go back in the state of California. There was a period of time, I believe, where the legislators allowed the victims of priests to go back. They had that one-year statute where they were able to go in and sue the church. And Will fell into that category. He was one of the people. I believe he and his brother went back. And so the church found, and if I remember, the priest's name was Gerald Ladner.
Gerald Ladner.
Gerald Ladner.
Linder, I'm sorry.
Linder. And found him, what would be the word?
Well, it was actually, what happened was Will and his brother decided to go in, and they got a lawyer who supposedly specialized in these kind of cases and went up against the Catholic Church, and so they sued. And they filed a lawsuit, and the Catholic Church settled with them. And of course, what later on Will told me, said, I don't think my lawyer really did a very good job of representing me. We didn't get a very big settlement. And I sort of poo-pooed him and clients are often unhappy with the amount of money they get. And I didn't think twice about it. And then this movie came out.
Well, it's also impossible to put a price on. I mean,
of course.
You've been assaulted. How do you?
Yeah. But this movie came out. Its name escapes me. That won the Academy Award for Best Picture. About the abuse of priests. And it was interesting because in the movie, one of the things it brought out was that these lawyers that were suing were actually in bed, no pun intended, but in bed with the Catholic Church. They were working out settlements with the Catholic Church, and the Catholic Church actually wanted these attorneys representing the victims because they were getting lesser amounts and they wouldn't talk. And so it was sort of an interesting thing, and I think Will was right. I think his attorney probably, because I know he did a lot of cases with the Catholic Church, I think he was probably actually working with them in a lot of ways.
Sorry to hear that.
Yeah.
Well, in the interim, so Will tracked down, and I don't know how he did it, and I certainly didn't help him do it. In the interim, Will tracked down Ladner and Linder up in Santa Clara County, and I guess went out to visit him, and one thing led to another, and Will ended up basically beating the crap out of him and was charged with assault. And interestingly, I remember in the discovery, we also found out that Linder, whatever his name was also a suspect in a homicide. He took another priest in a wheelchair up to the third or fourth floor of a parking structure, and somehow the priest managed to get from the wheelchair over the wall onto the ground floor without use of elevator. But that was never really pursued by Santa Clara County sheriffs. I have no idea what that was all about, but we did get a limited amount of information. So short version is, if you want to tell the story, Will goes in, he asks to see the priest, and go ahead.
Well, he
next.
Yeah, he basically said he lied to him. He went to the front desk and said that he was there with news about Linder's brother, that there had been a tragedy, and so they called Linder down to a room and where Will was waiting, and Will had a black suitcase or briefcase, and in it he had some documents that basically he wanted Linder to sign that admitted that what he had done, because Linder had never admitted to it. And he sort of was yelling at him, and I think probably just seeing him as well just sent him over the top, and
Sure.
He started pummeling him. And at some point, probably after maybe 15, 30 seconds, somebody heard Linder screaming, came to the door, started yelling at Will, and he just sort of froze, picked up his briefcase, and walked out. Linder was pretty badly beaten up, not to the point of, I don't think it was the point where he was unconscious or anything like that, but he beat him up pretty badly, and Will left, and they didn't know who he was because he hadn't left his name.
Right.
So what happened with me was I was working at the Garrigus firm, and you may remember a woman named Asia who was a receptionist, and she
very well.
She got a call from Will, and generally the process is when somebody would call with a potential case, they would send them to one of the younger attorneys to interview him and see what the case was. And so when she said, "I've got this guy on the line," I said, "Well, send him to Hago, one of the younger attorneys." And she said, "No, I think you're going to want to take this one." So I got on the line, and Will said, "The police are here at my door." This is 2 or 3 months after he beat him up. And I said, "Okay, why are the police at your door?" And he said, "Well, I think I killed a priest." And at that point, he didn't know if he'd actually killed Linda or not.
Yeah.
He'd been sort of monitoring the papers to see if there'd been any report of a priest dying. So I said, "Well, tell your roommate to go outside, tell him you've got a lawyer, and I'll be up there in about 3 or 4 hours." So I got on a plane and flew up there, and we turned Will in, and that's what started the whole process.
So fast forward to the actual trial. This became really interesting because there was an issue of the prosecution sort of misrepresenting. They had to put Lindner on the stand. He clearly survived. And they had to put him on the stand, and he was going to deny any bad behavior, anything that he had done that sort of prompted, if you will, Will's behavior. And that was an issue of the DA suborning perjury. And then you went through an entire motion and issue with the judge up there. And I forget the judge. Was it Sina?
Sina. Mm-hmm.
Yeah, who was the same judge that we had in a prior homicide.
Case. Mm-hmm.
So we had a relationship with him, all of us. I mean, he's actually a pretty good judge, but neither here nor there. The issue became that he was going to get up there, this priest, Lindner, was going to get up there and actually deny any wrongdoing, which would have been perjury. So tell me about that, because you got into it with the DA on that. So.
Yeah, it was sort of interesting because what happened is they put Lindner on the stand, and he testified for the better part of about 2.5 hours, talked about the details of getting beaten and the whole sort of his version and so forth. And it was 4:25, and court was adjourning at 4:30, and the DA looked at him and said, "Did you ever sexually abuse Will Lynch?" And he said, "No." And she said, "Did you ever sexually abuse Will Lynch's brother?" He said, "No." Court said, "Okay, we'll adjourn for the day and come back tomorrow, and you can start your cross-examination, Mr. Harris," which I was obviously looking forward to. Next morning we get there, Lindner has an attorney and gets in the stand and says, "I'm taking the Fifth Amendment, and I'm not testifying anymore." And at that point, I just went ballistic and started telling the judge, this is a mistrial. This is crazy. He's been allowed to tell his side of the story. And now he's going to, say, "I'm not going to take cross-examination." And obviously you can't do that in our system. And so the judge kind of hemmed and hawed. And before his final decision was, he just went in front of the jury and said, "Disregard any of his testimony."
Which is absurd.
It was, because obviously you can't unring that bell. But it did, in essence, the jury, realized that something was up and that Lindner was not going to face the music. And so it turned out in our favor.
And ultimately, Will testified, and he actually admitted to beating him.
Mm-hmm.
And they did what we refer to as jury nullification. And the judges, nobody wants to talk about it, but the judges tell you over and over and over, you have to follow the rules, you have to follow the law. And frankly, that's simply not true.
That's right. It's not.
It's not true.
There is such thing as jury nullification.
Right. You go back and do whatever you want.
It's a legitimate doctrine. But it was fascinating because I always tell the story. People get sort of tickled at it, that there was
hang on 1 second. We're going to have to take a break. Anybody that wants to call in, we'd love to hear from you. Area 818-850-7784. If you have any questions regarding this or any questions for Mr. Harris, please feel free to call. We'll be back right after this break. Thank you.
NBC Talk Radio, KCAA 1050 AM.
Are you having trouble sleeping? Are you always tired and worn out? Is it affecting your work and personal life? Well, South Pacific Sleep Lab can help you out. South Pacific Sleep Lab provides a personal study of your sleep patterns. With their trained specialists, they will diagnose your sleep habits and will give you a prognosis for getting a great relaxing night of sleep. South Pacific Sleep Lab has locations throughout Southern California, including Fontana, and will provide transportation to any of their locations at no cost to you. To find out more, give them a call at 844-SAD-5050. That's 844-SAD-5050. South Pacific Sleep Lab. Start resting easy and sleeping sound today.
Hi, my name is Phil Grandy, philsgang.com. Most people would love to be in the stock market, but they're scared not being in. They're scared about not getting out in time. Well, that is over, because now you can join Phil's Gang and my stock video program and follow me with specific stock on the video, and you will be out in time.
Find out more at philsgang.com or call 877-600-GANG. That's 877-600-4264. Why pay thousands of dollars for a weekend seminar when for only $39.95 a month? philsgang.com provides all the daily market investing information you need to make profits in the stock market. With over 40 years of investing experience, only Phil Grandy and the philsgang.com team provide daily live investing webinars, up-to-the-minute market updates, all the investing educational videos you can imagine. Don't hesitate to learn, invest, and make profits. Go to philsgang.com or call 877-600-GANG, 877-600-4264.
Bye-bye, sailor. No more sailing.
Okay, we're back. So you were just about to tell us a story.
Yeah, the judge basically sent the jury back, and Will had gotten up on the stand. And first thing Will said, I asked him a question. He said, looked at the jury and said, I'm not going to lie. I did it. And then he explained why. Kind of went through some of the details, and the jury then went back to deliberate. And about 3 hours after they went back to deliberate, they came out with a note. It said, what is jury nullification and can we do it? Well, the judge was very upset at this and sent back a note, which he was wrong about, that basically said you must follow the law, and that if you don't, you could be subject to prosecution for violating your oath, and kind of threatened him with it. Well, about an hour later, they came up with a verdict, and the district attorney's office figured, well, they've got this one in the bag. So they all came in there and sat in the courtroom. They had about 20, 25 of them. It had been a high publicity case. CNN had covered it. And so they were all sitting there waiting for the guilty verdict, and the jury comes in and says, not guilty. And I interviewed, the funny thing is I interviewed one of the jurors later, and I said, you sent that note out about jury nullification. How did you know about that?
Yeah.
And the juror said, well, one of the other jurors saw it on Law and Order last week. So television does help sometimes,
The
I guess.
CSI effect all over again.
I guess there'd been one of the shows had been about jury nullification. So one of the jurors knew about it. And I said, well, weren't you scared? The judge kind of threatened you. They said, well, we figured, if we all hung together, that what is he going to do? He's going to come charge all 12 of us. So,
wow.
Yeah.
That I didn't know. I did not attend the trial. I just went up there a couple times, did some work. The other thing that I thought was interesting, I don't know if changing gears and have you seen this, are you familiar with this new bail elimination process?
Yeah. One of the sort of things that I think is fascinating is the federal system, as you well know, has always had this
pretrial services.
Yeah,
right?
exactly.
Right.
They do pretrial services.
Right.
So if you're arrested, in general, in federal system, you may get arrested usually at 6 or 7 o'clock in the morning. By 12 o'clock, you're going to meet with a pretrial officer who's going to ask you questions about your income, your job, your house, your family. And then by 2 o'clock, that pretrial officer prepares a report for the judge. You go into court at 3 o'clock, and the pretrial officer recommends usually some sort of a bond of some kind. It's rarely cash. It almost always is just a signature bond. And it's a very good way of doing working. I mean, the federal system has worked really well for a lot of years.
Well, I spoke to our mutual bondsman, Hector Leon, yesterday. I'm going to try and get him in here to try and explain a little bit more about how it's going to work. But what is also interesting is I also spoke to a detective who wants to remain nameless. And if they don't get charges filed, they're kind of used to people bailing out. And if they can't put a package together within that 48-hour period, his indication to me is that they're going to end up with a revolving door situation, because if somebody gets arrested on, say, again, Friday at 4 o'clock, or LAPD is notorious for arresting people at 4:30 on Thursday, because then they don't have to arraign them till Monday morning. So they get that 4-day period to actually, or 3+ day period to put together a case. So in a situation where somebody gets arrested Friday afternoon, are pretrial services going to be sticking around for the weekend, or do people have to sit there? And subsequently, if they get arraigned, and the bail issue comes up at the arraignment, the problem is that it's going to jam up, and this is what the detective told me, that it's going to jam up their system and their ability to prosecute. And he said what you're going to see is people getting arrested in off hours where they can't put a package together. They're going to get kicked because they're going to get released because they can't put their package together for the arraignment within that 48, and they're going to walk them out the front door, and then they're going to hook them up and rearrest them and give them a whole new booking number. So he said what you're going to see is a revolving door, and it's again, from their perception, and the same with Hector. Hector's not really concerned about going out of business, but the point is that these bails are still going to be there. The amounts are still going to be there, and in fact, they say, some of these arguments I've been looking at online, they say it's going to put the bail situation, it's going to put the bail companies out of business. I kind of disagree. I think quite the contrary. In fact, it almost sounds like they're going to get more business, because bail's that would normally be $150,000 are going to be reduced to $20,000. It's certainly easier to come up with $2,000 than it is to come up with $15,000. So I think they're going to have much, much more business. And I could be wrong, and that's why I'm trying to get Hector on here. But
yeah, I'd love to hear what he has to say about it. As I understand it, it's going to be set up so that there are going to be 3 categories, and you have low, medium, and high.
Right.
And the low, if you are deemed to be in the low area, then you're automatically released. Doesn't go to a judge, doesn't do anything. The pretrial says you're low, you're released automatically and given a court date. If you're high, in the high risk area, you're not going to get bail, period. You're just out of luck. There is no basic ability. I guess you probably will be able to go in front of a judge and see if you can get it lowered, but I'm not clear on that. But then the medium is where the action is. Right. And if you're a medium, the original concept was that the judges would have kind of this taken out of their hands, but now what's happened is they amended it. It's going to be all in the judges' hands.
All in their hands, correct.
Yeah.
They're dumping it all back in their lap.
They basically are. Yeah.
And again, once you add on a new motion, as you well know, where you go into court and you're not just setting a prelim date, but you're now adding on a bail hearing, what's tantamount to a bail hearing, a bail motion. Ultimately, then that just kind of pushes the calendar further and further and further back. Seems to me like it's going to jam up the system. I get the need for it. And then the next question I have is, who are going to be these pretrial services? What are their qualifications? Who are they going to be? And what's their availability? Are we talking a 24-hour-a-day sort of program that they've got to have somebody sitting in each station house for either LAPD or LA sheriffs? So when somebody's brought in, they do an interview, because the law says, the actual bill, SB 10, I think it is, actually says within a couple of hours that they are interviewed.
Well, I think that's the biggest thing that's not being talked about at this point, and I think the bail bondsmen were pushing this, but not much of anybody else, is you're exactly right. We're talking about a brand new bureaucracy and a huge amount of cost. I mean, they're talking about the millions and millions that are going to be added to the system in order to have to pay for these people. And as you're right, there are no, I'm guessing, and it's at this point it's speculation, but I'm guessing what you'll see is probation officers will be converted to some degree to pretrial officers. But you're right, there is no, right now in the state system, there is no mechanism for
See,
this.
and I would think that under 830.1 that would be a conflict, because those are police officers. Probation officers are actually licensed police officers. So I would think that they're not an intermediary. They're not objective. You know, they're but you're
supposed
right.
to be.
Well, okay. I'll tell you one thing.
In
That's
reality.
a job I would apply for. I mean, that sounds like a cush job, just sitting there all day and listening to people, and yeah, I could do that all day long.
Yeah, you're
Well,
basically interviewing people. Yeah.
Yeah, and then there's this SB 1437, which is really fascinating. It's the felony murder rule. You've seen that.
Yes.
So California now is trying to obliterate the felony murder rule, and as you know, we had a case of a kid that's sitting down in custody. He's been down for about 18, 19 years now.
Yeah. Something like that. Sure.
And he went with this group of kids. He was the driver of the car. He was definitely not the shooter. He was never identified as the shooter. But under the felony murder rule now, what they're saying is, and I did look it up, that it does provide, it is retroactive. It does provide for people sentenced under the felony murder rule to come back for resentencing. And for those of you who don't know, if you are a participant in a crime and the crime ends in, if you go into, your partner goes in to rob a liquor store and somebody gets shot and killed, the driver or the getaway driver or whoever participated in it can be held liable under the felony murder rule. And the state of California is now trying to abolish that, change that, went into effect in 1978. And I think that is fascinating. But what's really interesting about it, and again, just my experience with defendants, is law enforcement can use that to force people to roll over on the actual shooter.
Oh, absolutely.
Well, they used to, I should say, but now not so much. If you get 4 or 5 people, and again, I don't know if I'm allowed to use his name, but in the case that you and I had or worked on, he was convicted, and again, it would have enabled the police, because we knew that there were 4 or 5 people involved. Technically, same with Ovasapian, which I've talked about before, so I'm okay with it. There were 5 people in this home invasion.
3, I think.
2 remained in the car. There were 5 total, but 2 people remained in the car.
Was there? Okay.
Yeah, but that's okay. It doesn't matter. Anyway, point being is that the 2 people still remaining in the car, 3 went in the house, but there were 5 people total. Of that incident, the 2 that remained in the car, if they had been found, let's say if somebody had gotten a license plate, which was not the case, but neither here nor there, somebody had been able to identify the 2 people sitting in the car, then those 2 people can be squeezed to find out who the actual shooter was, with the felony murder rule hanging over their head. Not anymore.
Yeah, it's, you're taught in law school. You gave kind of the classic example. You're taught in law school that felony murder is generally, the classic example is 2 guys go to rob a liquor store, and one of them, they both have guns, and they both agree ahead of time. Maybe one of them even has a fake gun or something. They both agree ahead of time, look, no violence. We're just going to go in and take the money and get out of here, but whatever you do, no violence, no violence. Well, they go in, and one of them panics, shoots somebody. The other one, who has clearly said ahead of time, no violence, no violence, well, you're out of luck.
Right.
You were in there, and your partner, you agreed to rob this liquor store. Your partner lost it, and so you're responsible. That's sort of the classic example. But as you pointed out, there's so many variations off of that, where somebody can be absolutely sort of within the category. Maybe they went in, they had a real gun, and they pointed it, and the other guy shot, but maybe they would have shot too. So yeah, there absolutely should be, found to have committed or been part of it. But then you have the other you go to the other extreme, and you've got people, like you said, who maybe, they take a guy to 7-Eleven, and he says, I'm going to run in and grab a Coke or something, and they're sitting in the car, and next thing you know, he's running out with a gun and jumping in the car, and they panic and they drive off. Well, guess what?
Right.
You're now going to be accused of murder, even though you didn't have a clue what was going on under the felony murder rule. So there are really extremes, and I think what this law does is it sort of recognizes that. It recognizes the extremes, because prosecutors have always used it, as you pointed out, to basically get people who are much, much less culpable to turn on the Moore couple.
Right. I had a kid, Eddie Morales, I can get into, who was convicted of murder. He was the driver, had no idea that the shooting was about to happen. All right, we have to take a break. 818-850-7784. Give us a call. I just got a text. We'll go over that in a minute. Thank you.
NBC Talk Radio, KCAA 1050 AM.
Hi, my name is Phil Grandy, philsgang.com. Most people would love to be in the stock market, but they're scared not being in. They're scared about not getting out in time. Well, that is over, because now you can join Phil's Gang and my stock video program and follow me with specific stock on the video, and you will be out in time.
Find out more at philsgang.com or call 877-600-GANG. That's 877-600-4264. Why pay thousands of dollars for a weekend seminar when for only $39.95 a month? philsgang.com provides all the daily market investing information you need to make profits in the stock market. With over 40 years of investing experience, only Phil Grandy and the philsgang.com team provide daily live investing webinars, up-to-the-minute market updates, all the investing educational videos you can imagine. Don't hesitate to learn, invest, and make profits. Go to philsgang.com or call 877-600-GANG, 877-600-4264.
Are you having trouble sleeping? Are you always tired and worn out? Is it affecting your work and personal life? Well, South Pacific Sleep Lab can help you out. South Pacific Sleep Lab provides a personal study of your sleep patterns. With their trained specialists, they will diagnose your sleep habits and will give you a prognosis for getting a great relaxing night of sleep. South Pacific Sleep Lab has locations throughout Southern California, including Fontana, and will provide transportation to any of their locations at no cost to you. To find out more, give them a call at 844-SAD-5050. That's 844-SAD-5050. South Pacific Sleep Lab. Start resting easy and sleeping sound today.
Interesting. I'm going to change gears all over again because I got an interesting text. Where the hell did it go? Here it is. Anyway. Are we on?
Yep.
Oh, we're back. Sorry. My mistake. I got an interesting text, which it's fascinating that you're here today because this question is, what is the most profound case you've worked on that is relatively unknown? I would say Cam Brown.
Yeah, that's probably true. I'd say Cam Brown as well. Cam Brown was accused of throwing his 4-year-old daughter off a cliff. And it was an interesting case because, in essence, Cam had
Not had a relationship with his daughter for the first 3 years, didn't know she existed, and then found out, and then started the last year, had become what I showed the jury was a very good father and very attentive and so forth. Cam was sort of the ultimate outdoors person, and he was always sort of, he lived up in Colorado at one point, up in the hills in a cabin with no utilities. And
Ted Kaczynski.
Yeah, sort of that type. I mean, he was very much, but he was always outdoors and surfing and doing all these things. And so he took his daughter to this place down in Rancho Palos Verdes, to a playground one day, and so he took her hiking up on this cliff. And for Cam, you just have to kind of know him.
Right.
In his mind, it just was something he'd been doing all his life, and he didn't portray it as dangerous. It was obviously very stupid. And his girl, his 4-year-old girl, was playing with him, and she, according to Cam, slipped and fell off the cliff and died. And the prosecution basically created this whole story that he had thrown her off. And I never believed it for a second. I knew
Well, they
Cam,
said because he didn't want to pay child support.
yeah, he didn't want to pay child support and stuff like that, which his parents were paying. It was sort of a stupid argument. But I felt like from the very beginning, I felt like, Cam was definitely not the sharpest tool in the shed, but I kept saying, look, this is just who he is. He's kind of a doofus, and he would never hurt his daughter. He actually loved her a great deal, and he would never hurt her. And I felt like that this was clearly an involuntary manslaughter. I mean, he was clearly guilty of that. You don't take a 4-year-old
Well, yeah, it was
girl
completely
up on a cliff.
irresponsible.
Oh, it's totally irresponsible.
Yeah, I had an amazingly intelligent, highly trained dog that would do exactly everything I told him to, I wouldn't take him up there without a leash.
Of course
that would be
not.
crazy.
And it was absolutely.
Nor let him get near the edge.
Yeah.
It was irresponsible.
And he wanted to show her, the sun setting over the bay and all this kind of stuff. And he said all that. But I don't care what your excuse was. You don't do it. So we went to trial in Torrance. The jury hung. They decided to retry it. We came back downtown. They moved it to downtown. I tried it there. The jury hung again. And the third time, you and I did not do the case together. We did the first two together. We did not do the case together.
The third time, the judge pulled me in. He contacted me and asked if I would come in and, by special appointment, do it because the attorney that was handling the case was clearly not really capable of handling that type of a case, I believe. That's a whole separate issue. But the judge brought me in, so I did try and help out with that. But he, again, it was a lot of resistance. It's most resistance I've ever had with an attorney when I'm trying to help them. Anyway.
Well, he got convicted, and he's now looking at life in prison, and he's got appeals out. But I know when I bring up the subject, people hear immediately, oh gosh, 4-year-old girl being thrown off a cliff.
Oh, yeah, it sounds horrible at first.
And there's just this horrible reaction, and understandably so.
Well,
I don't believe for a second he threw her off.
And this sort of goes back to the jury nullification in Cam's case. What's interesting about that aspect of it is in the second trial, the jury came back and basically acquitted him because, again, they were given a series of lesser included, so he was actually charged with first degree premeditated, but they also tossed in second degree, and I think voluntary, and I don't know about involuntary. Did they?
They did an all invol, yeah.
So there were 4 options there, and the jury came back and found him not guilty, although they didn't sign the verdicts, of the first degree.
That's correct.
And when you asked the judge, well, you tell it.
Well, they came out and they said they were split 6 for second degree murder and 6 for involuntary manslaughter. And so the judge said to him, asked the jury foreman to stand up and said, is this where you are? And they said yes, and the foreman said yes, and he polled the jury, and they all said yes, this is where we are. So he declared a mistrial. And at that point, what you're supposed to do, what the judge is supposed to order, is for them to sign the verdict form that basically for first degree murder saying they have found him not guilty of that and that they are hung on between second and vol. And he did not have them do that.
Intentionally.
I'm not sure as a bar attorney I'm allowed to
Well,
I'm allowed to say that, but it certainly was not a
I'm not a licensed attorney.
Oh, it was certainly an unusual thing for a judge not to do. And then so when the trial came back for a third time, when they were going to retry it, the argument was made, well, they've already found him, you can't try him on first degree murder because he's already been found not guilty. And the judge says, well, no, they never signed the form. So,
right.
And sure enough, they found him guilty of first degree murder.
Right.
So,
yeah, that was really a difficult one. That was very, very hard to have to stomach because, again, you're right, when you get to know Cam. But there was a whole backstory behind there, and I don't want to get into the entire thing, but the backstory of that was that the wife got remarried to somebody, and I don't know if you even remember this, again, as the investigator, this is what I was doing. So when the wife remarried this gentleman, forget his name, doesn't matter, he had been married to somebody else who actually went to prison on drug charges. And the court forced him up in a California county, but northern, the court forced him to take care of the children and pay child support for children who weren't his, stepchildren, because she had been shipped off on a federal rap. She was now in Tennessee or Kentucky. And so when he found out, when he met and married the mother of Cam's daughter, and found out that she had a child and the father was alive and well, he's like, I'm not picking up the tab for another kid. So we need to go after him. And he's the one that initiated the whole process of child support. Did you even?
I don't think I remember that.
It's kind of irrelevant. So I don't know. I mean, I would have written it up, but it's not really relevant to it. It's sort of the origin, if you will.
Well, I know one of the things you found, which was interesting, it was toward the end of the second trial, because we got an anonymous tip and you followed up on it, was that the child had been over in England. The mother was from England, and that there was a gentleman over there who knew the family and whatever, and said that they had a lot of problems with the young girl keeping her under control. She was always running around, and at one point, as a joke, I guess, one of the family members gave the mother a leash because she couldn't control her, and she was falling down things and stuff like that.
And she fell into a lake or something.
I think she fell into something.
Fell down a hill into a lake.
Yeah, that. Unfortunately, that was toward the end of the second trial, and we weren't able to get that into evidence. But yeah, I remember that was a very unusual case, and like I said, you bring it up to people and they immediately cringe, but I think it's a pretty classic example of somebody who's spending life in prison and shouldn't be.
And at the time, though, Cam's current wife then was a civil engineer for the county or city of Ventura. So there was money, there was a job, there were assets to pay the child support. For them to make that allegation was absurd. In fact, Cam was trying to get more time with her.
Yeah, that's right. I think the best argument, because they said he didn't care about his daughter, I think the best argument we made was he lived in Manhattan Beach and the daughter lived in Orange County, and every time he saw her once a week. And every time he did, he had to drive down to Orange County, pick her up, drive back to Manhattan Beach where they would play and do things, take her back down to Orange County and drive back to Manhattan Beach. He was on the freeways 5 to 6 hours a day just to see her for 2 hours. So I don't know many people who would do that if they didn't care about their child.
And the incident, I forget the year, but the incident I remember was, I believe, November 2nd. And October 31st, he had dressed her up and taken her to a Halloween party.
Yeah,
you know, and we had pictures, and we found the Halloween family. Yeah. So
forgotten about that.
Yeah, that case was very difficult, and I think it had some minimal exposure into the news. I think the biggest reason it had any exposure is because one of the reporters ended up marrying the DA in that case. Yeah, she's still on the air as we speak, and I won't get into that. But anyway, that's that. I hope that answers your question. But that was the worst case that we ever had to deal with. I would say, as far as the emotional aspect, there's always a bunch of those. That's only one, but one where you're the hardest part, and I say it all the time, is when you're defending somebody whom you know to be not guilty.
It's much harder.
Yeah.
It's much harder because the pressure's on you. I did a trial fairly recently where I had a client who unfortunately just would not tell me the truth.
No.
People, well, it's funny because, most clients will come in and to their lawyer, they'll sort of tell you, what actually happened or what's going on. To some degree, they may stretch the facts or whatever. But you recognize that, look, I'm your lawyer. You better tell me the truth, because as I did in this trial, I stood up and I basically made an idiot of myself because he had told me something. And when a witness was on the stand, I found something the witness carried with him, and I made a big production out of it in front of the jury and grandstanded and was, thinking I had a really great point. And it was based on something my client told me, and turned out it was absolutely wrong. I looked at my client and he said, "I never told you that." Just looked at him and kind of shrugged my shoulders and said, "Well, at the end of the day, I get to go home." So,
yeah, I've had those conversations on numerous occasions. So the other thing, I guess, I was not necessarily trying to avoid, but since we have the time, Scott Peterson, you recently did, and I've not seen it because I don't have television, but you recently did a special on Peterson, and you're of the belief that the actual death penalty aspect of Peterson is going to that at least is going to be reversed.
I don't think there's any question the death penalty will be. The jury selection process, the judges got it wrong in terms of the death penalty. He just misread the law, and it's pretty clear. And I don't think there's any way that they can get around that. So I do think the death penalty part will be struck. The question obviously will be if he gets a new trial based on the other grounds.
Well, back up and sort of go back through the motion and tell us where it's at. Because to be honest with you, I haven't really, I had spoken to Cliff Gardner a couple times on it from the part that I worked on Peterson, from more of the civil aspect. All right, well, I guess we're going to take another break. When we come back from the break, we'll talk about the appeal. Again, you're listening to All Things P.I. Give us a call, 818-850-7784. Any other questions, you're welcome to text them to me at area 818-744-9827, and we'll be right back. Thanks.
NBC Talk Radio, KCAA 1050 AM.
Are you having trouble sleeping? Are you always tired and worn out? Is it affecting your work and personal life? Well, South Pacific Sleep Lab can help you out. South Pacific Sleep Lab provides a personal study of your sleep patterns. With their trained specialists, they will diagnose your sleep habits and will give you a prognosis for getting a great relaxing night of sleep. South Pacific Sleep Lab has locations throughout Southern California, including Fontana, and will provide transportation to any of their locations at no cost to you. To find out more, give them a call at 844-SAD-5050. That's 844-SAD-5050. South Pacific Sleep Lab. Start resting easy and sleeping sound today.
Hi, my name is Phil Grandy, philsgang.com. Most people would love to be in the stock market, but they're scared not being in. They're scared about not getting out in time. Well, that is over, because now you can join Phil's Gang and my stock video program and follow me with specific stock on the video, and you will be out in time.
Find out more at philsgang.com or call 877-600-GANG. That's 877-600-4264. Why pay thousands of dollars for a weekend seminar when for only $39.95 a month? philsgang.com provides all the daily market investing information you need to make profits in the stock market. With over 40 years of investing experience, only Phil Grandy and the philsgang.com team provide daily live investing webinars, up-to-the-minute market updates, all the investing educational videos you can imagine. Don't hesitate to learn, invest, and make profits. Go to philsgang.com or call 877-600-GANG, 877-600-4264.
Okay, so we're back, and we're going to do this last segment on Scott Peterson. I know, old, antiquated, nobody wants to hear about it anymore. But I think it's really more of the appeals process. Number one, the state of California has to pay for it. Cliff Gardner is, who's an amazing appellate attorney in the Bay Area, is the one that was handling it. Now, he actually filed the appeal. Did he complete it? Because, again, I haven't spoken to Cliff in a while.
He has. There's two separate appeals. There's one that's called a direct appeal, and then there's a second one called a habeas. Cliff did both, or his office did both. The direct appeal has been filed. The prosecution responded. Cliff gave his reply back. They're waiting to set oral argument. Now, this has been, because it's a death penalty case, so it takes a while. I think it's been, 12 years now? 13 years?
Yeah, quite
something
a while.
like that. He filed it, 6-7 years ago. So it takes a while for the process to work. But they're just waiting on oral argument, the court to set an oral argument for it, and all the paperwork's in.
Now, Cliff is petrified of speaking in public, so who is actually going to be doing the oral argument? Is that something that you would come in to do? Or
No. Cliff's great. Cliff's a terrific speaker. He's terrific.
Yeah, okay.
I think the world of Cliff. I
do too, but I know he doesn't like doing.
He doesn't like to do trial work. Yeah. He's always very complimentary of trial attorneys, because he said I could never do that. But his success rate is phenomenal, and appellate attorneys don't have much success, and he has tremendous success. So.
I'm curious, when you're given and if you know the process, because I personally don't. So if you, again, a death penalty, you get an automatic appeal, and the state pays for it. Did he get to choose Cliff Gardner as his attorney, or you guys, I'm sure, recommended him?
Well, the way it works, because there are two appeals, is the family actually paid Cliff for the direct appeal, which then, as you said, the state's then paying for the habeas. So the state then looks at it that, well, if you're doing the direct appeal, we'll pay you for the habeas.
Oh.
So that's how he got to keep Cliff for the habeas. But the family actually paid for the direct appeal. And that was done to, I know it sounds crazy since it's been 12, 13 years, but they actually did that to speed things up, because it would be even longer if they hadn't paid for it, the direct appeal. So.
Yeah, then it just becomes another file and falls to the bottom of the stack.
Absolutely.
Yeah,
Takes
interesting.
Forever. But
yeah, the appeals process, again, I know that there is just an entire group of attorneys that do nothing but appeals. I constantly get calls from them on cases that I had worked on, and since it's based more on the transcripts, unless there's new information, it doesn't really make a whole lot of difference.
Yeah, and as you know, that if you're doing a direct appeal, the direct appeal is simply you can't go outside what happened in the courtroom.
Right.
It is only what happened in the courtroom. A habeas, you can go out and try and find new information and new things, and I know you've been hired to do some of those, where you go out and try and find different stuff or things that may have changed things. And in Peterson's case, they did go out, and they've actually got 2 or 3 things that are extremely, I think, powerful, and that's that was put into the motion. And then this woman who's become sort of obsessed with Scott Peterson, it's a crazy story, but she apparently is.
But this is the woman that put the show together that you did.
Well, she actually produced it, and she's living in Ukraine. Don't ask me. She's, I guess, married to some oligarch and has more money than she knows what to do with. And she turns on television. Somehow or another, the Scott Peterson movie was on in the Ukraine. Don't ask me. I don't understand how.
Miracle of reruns.
Yes. So she sees it. She becomes obsessed with it. She ends up doing a lot of research and starts believing that Scott is innocent. So then she goes and hires this woman who is a documentary filmmaker, Shireen, a very good one. And she goes and hire her in New York to do a documentary, and she pays, I don't know, the documentary was well funded, a couple $1 million to do the documentary, which Shireen then did. She interviewed myself and Mark and others, did it, sort of introduced it at the Palm Springs Film Festival. A person came up to her at the Palm Springs Film Festival and said, wow, this is as good as that Making of a Murderer thing that's so popular on Netflix. Can we buy it and do a series? So they did a 6-part series on A&E television, and it was basically, a lot of it, especially the 6th episode, was based on the new information that's come out. So it's kind of, it was kind of a fascinating process. But
Well, I haven't seen it, so what's the new information that's come out?
Well, there's 3 things. The short version is that the doctor who testified, or the prosecution had a doctor testify as to when the baby would likely have died, and based on when some calculations that were done by a professor from Sweden who had figured out a method to determine all these kind of things when a woman becomes impregnated. And they used his method, and this prosecution witness explained that the baby was killed on Christmas Eve based on this calculation. Well, Cliff actually got a hold of the professor in Sweden who did whose calculations they relied on, ran the thing by me. He said, no, they did it totally wrong. And based on the calculations, the baby was actually alive for 3 or 4 more days afterwards. So that's pretty huge.
That is huge.
Then they also found that the mailman had come to the house, and every time the mailman came to the house, the dog was in the backyard. That's where he stayed. It would bark crazy and go bananas. And on this day, the dog wasn't barking. And what the importance of that is because we had always said that Lacey was walking the dog after Scott left. Well, that mailman came after Scott left. The dog was gone, wasn't in the yard, wasn't barking at him, and he found that very strange. And essentially, that evidence seems to indicate that, yes, the dog was out walking with Lacey after Scott had left.
So Lacey could not have been with him to be dumped off in the boat. And,
right, exactly.
And the other thing, too, that people seem to ignore, and I know it was brought up in the trial, is that cell towers, if I remember correctly, put Peterson somewhere else, where Lacey at, if I remember, it was like 8:35, 8:32 in the morning, was on her computer looking at bathrobes on the Macy's website.
Yeah, that was probably the most frustrating part of the trial is our computer expert, did not find it, and the prosecution's computer expert did not find it. Mark got up and did a really brilliant cross-examination of their computer expert. He was going through his notes. He said, well, I do see something here. And by the time he had finished, the prosecution's expert had admitted that Lacey was on the computer that morning, or somebody was on Lacey's computer that morning at 8:30, when supposedly by the prosecution's theory she's already dead, looking at sunflower umbrella stands and bathrobes. And Lacey loved sunflowers. She had a sunflower tattoo. And So the frustrating part about this is we thought, wow, we've hit a gold mine here. Very excited, and in fact, the prosecution got up in their closing argument and said, well, we really can't say when she was murdered, but we just know he murdered her. So after they convicted, these 4 or 5 jurors go on Larry King.
Yeah, this I remember.
Yeah, and so Larry King asked them, said, well, what about that computer evidence that showed that she was in the computer? And it was like blank looks on all their faces. And one of them finally said, well, I don't really remember that. And it was like, you got to be kidding me. This is the key piece of evidence, and not one of them even paid attention enough to know it. So, yeah, that was a little frustrating.
Mind-boggling.
Yeah.
Yeah, that's the issue, is that you get these jurors that follow the hype, and they unfortunately, and I think Marcia Clark set the standard, even though I get it, she's not a juror, but when she got $4.5 million to write a book about a case that she lost, and then you get these other jurors. I remember in OJ, there was he was a FedEx employee who was at some point after the fact removed from the jury, and he got like an HBO special called Juror Number 5.
Wow, I didn't even remember.
Yeah, and he talked about what was going on behind the scenes and the prejudices, and it was all about race and what have you. But and the conversations that the jurors were having, when of course they're not supposed to be discussing anything. And he got kicked off. And again, I remember in Scott Peterson, the juror number 1, if I recall, was a doctor, an MD with a Juris Doctorate, with a law degree. And he was the one that was sort of a lone holdout, if you will, for not guilty, saying there's no evidence. Again, simply no evidence. And so tell that story, because the jurors took care of him.
Yeah, he was, as you said, he was an MD and a JD, and he was the foreperson. He was elected the foreperson, obviously, because he was very bright. And what he did was he started going through the evidence very slowly, day by day, with in deliberations. And there was one gentleman in particular who we knew was a real problem. He was kind of a big fella, kind of physically imposing. And this lawyer was the opposite. He was kind of a small guy. And after, I think it was, I want to say 5 or 6 days of deliberations, the lawyer sent out a note and said, I don't feel safe. I'm being physically threatened, and I want off this jury. And the judge, instead of doing what he should have done, which is get rid of the person who's doing the threatening, let him off, took him off the jury. And I've always felt like that if he had stayed on the jury, that jury would have definitely hung. At some point, we understand that it was actually 9-3 in favor of guilt. So there were 3 people holding out. And I think the lawyer was sort of helping to convince people or whatever, but he got... Well,
believe it or not, I actually sat on a jury a couple of years ago. They didn't kick me off, which I couldn't believe they did that. And there were a couple jurors. I was actually chosen foreperson as well. And there were a couple jurors that when I asked them what they thought, and they said, whatever you guys think is fine. And I said, no, it's not. You're here to render an opinion. That's why you're here. That's the whole purpose. I said, you have to, and he literally, this nice gentleman, literally just said, whatever you guys decide.
Yeah. Yeah, when we do jury selection, we often categorize people as lions or sheep. You've heard us talk about that. A sheep is just basically somebody who is going to go back there and say whatever you guys want.
Yeah,
and they're
that's
not going to
fight.
They're just going to go along with everybody.
We're about to, unfortunately, run out of time. But the other thing I wanted to talk to you about, and we're going to have to come back and do it, is I don't know if you heard about this, South Carolina, 902 indictments in one day, 39 seconds on average per indictment. The judges threw them out. Obviously, the absurdity in the grand jury, the 23 members of the grand jury went in and said, we have 900 files. And they said, well, we'd like to get through it today. We'd like to get them all done in one day. So, and of course, 900 indictments, but I think 500 some odd actual defendants. Everybody was indicted, and the judge tossed them all out, every single one of them.
Good.
I mean, they're not, they still have to go back and face the music,
sure,
for lack of a better term.
Well, as they say, a grand jury will indict a ham sandwich.
Ham sandwich. That was the first thing I thought when I read the article. All right, so we are unfortunately out of time. We will be back next week. I'm going to try and get Hector Leon, our favorite bail bondsman, to come in. You're listening to KCAA Radio, All Things PI with Scott Ross. If you have any questions, we're at allthingsprivateeye@gmail.com or scottross@hotmail.com. My cell phone is 818-744-9827. You can text me anytime you want or give me a call. Thanks for listening. See you next week.
KCAA Loma Linda, 1050 AM, 106.5 FM, and now 102.3 FM.
NBC News Radio, I'm Lisa Carter. President Trump is trying to put some space between himself and his former personal attorney. Michael Cohen pleaded guilty Tuesday to several charges related to hush money payments made to two women. Trump telling Fox News this morning,
in all fairness to him,